Good morning, everybody, and welcome to our webinar on the employment rights changes and getting ready for October 2026. My name is Jess Bates and I head up partnerships, and I'm very lucky to work alongside some wonderful colleagues in Access People HR. And I would just like them to introduce themselves, Bethan and Andrea, please.
Well, hi there. My name is Beth Ann Rossin. I'm the in-house employment legal counsel here at Access.
Good morning, everybody. I'm Andrea Williams. I'm a senior solutions consultant at Access, working on People HR and also our learning suite as well.
Thanks both. So we have got about an hour set aside today, and we've got some really good stuff to cover off with you. And actually, we can see by the number of people here today that it's obviously a topic that is of great interest to the audience that we're talking to. So first of all, we have got Bethan, who is going to guide you through the changes that are coming up with the upcoming Employment Rights Act, talk you through some of the key principles, but what the implications might be for yourselves, your staff, and for the businesses that you represent as well. We're then going to talk through a little bit how the software can help support with some of that. And then we've got Andrea, who's going to give a live demo of a joined up HR and learning ecosystem. And again, looking at the ways in which that can be set up to make sure it supports and helps you through these changes that are coming up over the next 12 months or so. Worth mentioning, we want this to be interactive. There's a chat function on the right-hand side. So please do drop any questions or queries that you have in that chat. And one of the really nice features of this platform is that you're also able to vote. So if you see another question that somebody else has raised, please vote it. And the ones that are the most pressing, the ones that probably connect with most of the audience on this call, will come up to the top, and we can make sure we've got some time set aside at the end to answer some of those questions. Just worth mentioning, we're not here to give legal advice, so when it does come to Q&A, we can't give specific advice on your environment. We'd really like to focus any questions around the technology where possible, if that's okay. So without further ado, we'll get started. And really, I just wanted to talk a little bit first and foremost about the landscape. So if you're sitting here watching the webinar, feeling a little apprehensive about what's to come, you're not alone. And in fact, if you look at the statistics, that's a common feeling across lots and lots of HR leaders. So looking at the stats first and foremost on the left-hand side, there is 75% of HR leaders are concerned and have fear around the unfair dismissal changes. That's from the FSB survey. And actually, if we look at small employers, 92% of them have concerns about the bill and the implications it has for them as a business. So, you know, there's a lot of, I suppose, anxiety around what is upcoming. And if we look further to the right-hand side, only 1%, I think that's tiny, of line managers, so people working with staff, feel fully prepared. And as many as 51% of them are also saying they feel unprepared. So, you know, there's a lot of anxiety and concern around this. And at this stage, I'd actually like to pass to Bethan, because what we're going to start doing is talking you through and guiding you through what this means for business. But we'll also talk about the ways in which we can use software to help support it. Thank you. Over to you, Bethan.
Thank you so much. Good morning, everyone. Thank you for joining. Apologies, I'm just having a little look with my slides, being very techie. So, as has been said, I'm going to take you through the Employment Rights Act 2025 and what you need to know for your business. It's a very large act, but I'm going to take you through the highlights and the key important takeaways. So let's get started. Okay, so the Employment Rights Bill was published on the 10th of October 2024. The purpose of this bill was to introduce 28 significant reforms to UK employment law. The bill itself received royal assent on the 18th of December 2025. So we're no longer talking about the Employment Rights Bill, we are talking about the Employment Rights Act. And it is live, it is happening, it is law. So what does this mean for employers and employment law changing? Well, as I've mentioned, there are 28 major reforms to UK employment law. We're going to touch on those today. The relief of the Act coming into force is that these changes are going to be staggered. They're going to be implemented. Some have already started, but from a timeline from April 2026 all the way to 2027. So it breaks it down into small, manageable chunks for us. So who does this apply to? It applies to England, Wales, and Scotland. It does not apply to Northern Ireland. So my key takeaway right at the start for you is this act is no longer theoretical. It is real and it is happening. So it's time to get your businesses up to date and ready for the changes coming into force. Right, so, excuse me. Let's take you through 3 separate sections. They are day 1 rights, enforcement, and trade unions. Focusing on day 1 rights, let's start with statutory sick pay. So we've done a little table here so you can have a comparison. At the moment, an employee needs 4 days of sickness to commence their statutory sick pay, and they need to earn above the £123 week limit. The change is SSP is now going to kick in for your employees from day 1 of sickness. So you're going to be paying more SSP and you're going to be paying it earlier. And the lower earnings limit is now removed. It's going to be applicable for all your employees. Moving on to paternity leave. So at the moment, an employee needs 26 weeks service for paternity leave. This limit is now going to be abolished and you can have paternity leave from day 1 of employment. Again, moving on to parental leave, you currently need 1 year's service to take parental leave, unpaid parental leave, and it's now going to be removed altogether. So again, start thinking about how these family changes are going to impact your business. And unpaid parental leave is becoming a day 1 right, as I've already said. Enforcement. So, a big one that's coming out of the Employment Rights Act is the establishment of the Fair Work Agency. What is the Fair Work Agency? Well, those details are still coming out thick and fast, but it is essentially a separate government agency that will have enforcement powers. What kind of cases or work will they be carrying out? We are expecting them to try and shift some of the burden of cases such as wages, sick pay, holiday pay, things that are more like contractual and can be calculated rather than claims that are more complex and require specialist input such as discrimination claims. The importance for employers is the Fair Work Agency can bring tribunal claims on behalf of workers. That's a major one to underline 3 times. If you had a subset of employees, all of them were not paid correctly, and the Fair Work Agency noticed this, they could assist them by bringing a group tribunal claim. Another key element of the Fair Work Agency is they can enforce financial penalties for employers. So there's going to be money on the line if you get this wrong. And they can also attend workplaces to inspect record keeping. We don't have many details about that at the moment, but think about it. If you've got pay records for how all your staff, you're going to need to have them available and organized. Trade unions is a big topic that's covered under the Employment Rights Act, and lots of changes have come into force already and are moving forward. So one of them that is well needed is electronic balloting is going to be introduced rather than the traditional paper balloting. There is going to be a simplified trade union recognition process. At the moment, it can be quite difficult for an employer to recognize a trade union. That is going to be simplified. So we are expecting, I say we as employment lawyers, we are expecting to see more trade union memberships and activity in the future. There is going to be a specific duty for employers to inform workers of their rights to join a union. So no longer is it going to be optional. It is going to be, no, your employer needs to say, if you want to join a trade union, you can. There are various other updates in force that already came into place from 18th of December 2025. If I'm honest, I could create a whole separate training session on trade unions. It's such a big element of the Act, but I've given you the key takeaways for today. I've just added one of my little access tips at the bottom. So start thinking about reviewing your payroll systems. updating your contracts of employment, and preparing for higher SSP costs. Get prepared now and it'll help you later on down the line. Okay, so looking ahead to 2026, well, we're already in 2026, and I don't know about anybody else, but it is flying by. We're in March already. So let's have a look at what's coming into force. Fire and rehire. So, fire and rehire is particularly controversial at the moment anyway. Think about those cases in the news where everybody's all gathered in one Zoom call and they're fired and then offered a rehire straight away. It is already seen as bad practice in employment law, really. It is now going to be enhanced further, and that fire and rehire will become automatically unfair. This is if the employee did not agree to this fire and rehire process, or if it's very clear from the evidence presented that that employee is simply being replaced. There is a defense for employers when it comes to the use of fire and rehire, but this is going to be really honed in on cases where the employer is suffering from financial collapse. So it's quite an extreme circumstance where fire and rehire can be used, so keep that in mind. The fire and rehire changes under the Employment Rights Act will also cover replacing employees with contractors and consultants. This is something a lot of large organizations do at the moment. They assess their costs, they assess the ability, freedom that that person has, and they replace their employee with a contractor. That's going to be scrutinized under the Act. So have a think about your real reasons as to why you're doing that. A big one under the Employment Rights Act is harassment. So there is going to be an increased duty to take all reasonable steps to prevent sexual harassment. What does that mean? Well, that's an excellent question, and I'm going to use a lawyer's favorite word again, as it's quoted there, which is reasonable. What is reasonable? That depends on the circumstances of your business. How large are you? How many employees do you have? Internal HR teams, external HR teams. But really, what reasonable steps, examples that you should be considering are things like getting your policies and procedures up to date, making sure they are very clear and that your business has a very strong zero tolerance approach to harassment in the workplace. A main element of that is going to be training. It's all well and good if you have policies that say we don't accept this, but what actually happens when reports of harassment come in? Have you got a process, and does your senior management team know how to follow this? Employers will also be liable for third-party harassment unless they took all reasonable steps to prevent this. So think about people that come into your business daily that are not your employees or your consultants, contractors. Think about suppliers, think about visitors to staff. You are going to be held liable if harassment takes place on your workplace. But not only that, it's if harassment does occur, the employer needs to take reasonable steps to rectify that and ensure it never happens again. A biggie under the Employment Rights Act is disclosing sexual harassment itself can now count as a qualifying disclosure for whistleblowing. Again, I could probably do a separate training session completely on whistleblowing and protected disclosures. It's a complicated area of law, but as we know, the simplest form is employees can blow the whistle when they see or experience misconduct in the workplace. This can be very, very serious or it can be minor. But what the Act is carving out here is that sexual harassment is specifically honed in as an example. A large one for employers that I'd love you to red pen today is tribunal time limits are changing. So at the moment, an employee needs 2 years qualifying length of service to make a claim for ordinary unfair dismissal. They have 3 months, and if you want to be very technical, 3 months minus 1 day to bring a claim for unfair dismissal at an employment tribunal. That time limit is now going to be extended to 6 months. So let's have a think about how that impacts employers practically. An employer will have 6 months after they've been terminated or they've resigned as a result of a contractual breach, therefore contractual constructive, there you go, unfair dismissal. 6 months is a long time to have a think about, actually, was I mistreated? Do I want to take some form of litigation? So, as employment lawyers are expecting an increase in particularly unfair dismissal claims, but tribunal claims in general. I've already touched on trade unions. So I've just flagged here again, another element is there is improved access to the workplace for recruitment. So expect potentially trade unions or trade union reps to be at your door saying, would you like to join our union? And you cannot unreasonably restrict that for your employees. Collective redundancy. So there's going to be a new threshold test to be implemented. And even last night, I actually saw some legal updates that have come through following the Act, which is talking about what actually classifies as a business establishment. So it's quite easy if you've only got one establishment, one office. But what if you've got an office, a warehouse, stores, however you may see it? All of that could be considered as an establishment for your collective redundancy figures. More details are coming out, and we'll share them when we know more. The protective award for failure to collectively consult for redundancy processes for your employees is going to be doubled. So at the moment, if you fail to collectively consult, so you've got over 20 employees, you need a 30-day consultation. Beyond that, you need 45 days consultation. If you fail to do that, the individual award for one employee is going up from 90 days pay to 180 days pay. So it's quite a significant jump. And think about that already, calculating that, how many employees could get that payout, and it's doubled. Cash tips. So this is obviously particularly relevant to the hospitality industry. So the consultation requirements are going to be introduced, with potentially appointing trade unions or employee reps to deal with cash tips. We've all heard in the news circumstances of where tips are maybe hoarded by senior management or by certain employees. There's going to be rules in place about that. Okay, so let's look ahead to 2027, which may feel a long way away, but it's creeping up fast, so let's get prepared. Unfair dismissal, I've already touched upon it, but this is probably the hottest topic under the Employment Rights Act. When the bill was being put together, there was quite a lot of fear in the employment law community that this was going to come into force instantly. But luckily, we have until 2027 to get our heads around it. So, the length of service requirement to bring a claim has been reduced from 2 years to 6 months. I've already mentioned that, but I've put in a little bracket here that there was lots and lots of information out there about this being a day one right. So an employee joins your company and straight away they have the ability to make an unfair dismissal claim. Luckily, there was some additional sense applied to the Act, and we're given a 6-month period to decide. During that 6 months period, which is now kind of being referred to as the initial period of employment, we're expecting the Act to bring into force a light touch dismissal process. So, this is where the use of probation periods really come into force for employers. They've got to be in your contracts of employment. Ooh, and they've got to be clear. Sorry, I'm in the dark slightly at the moment. Well, just add a little bit of ambiance for you, but hopefully you can see me. And the compensation rate at the moment, you have 52 weeks gross pay for your compensatory unfair dismissal award, which is 52 weeks or capped at £118,223. So remember, if an employee brings a claim for unfair dismissal, there are 2 awards. There's the basic award, which is the same calculation as a statutory redundancy payment, considering age, length of service, and gross weekly pay. That's what that cap is talking about at times, but more in relation to the compensatory award. So that cap is going to be abolished. What does that mean? It means technically the compensatory award is endless. So how many years are they out of work for? How much have they financially suffered as a detriment? It's going to increase costs for employers. So especially with your senior employment team, have a think about that. 0 hours. So there's been 0 hours is another controversial topics for employers, but at the moment, the right to guaranteed hours is looking at a Oh my goodness. A 12-week reference period. I don't know why I gave my slides so many tongue twisters just to entertain you, I think. But so we'll be looking at what guaranteed hours can a 0 hours worker have, look back over 12 weeks as to what they've previously worked. Another element of the Act is there's going to be reasonable notice of shifts required. This is different because at the moment, 0 hours contracts are used very much so like, Bethan, we'd like you to work tomorrow. Can you turn up? Yes or no? Reasonable notice is going to be required. It's not specified what that is just yet. And on the flip of that, there is going to be compensation for those employees for short notice cancellations. So if an employee at the very last minute, they have their shift and you say, actually, we don't need you anymore, you may have to pay them for their time that they've allocated to work. Let's move on to flexible working. Pause for dramatic effect. So the refusals for flexible working requests, if you want to say no, must be reasonable. There it is again, that legal word. And it is not just going to be based on the 8 statutory grounds of refusal. They still remain in place, but you're going to have to expand further. Why have you chosen that statutory ground to say no to the flexible working request? And would a hypothetical tribunal judge deem that as a reasonable approach for that individual? You're going to have to provide written explanations of why the refusal has taken place and again, why it is reasonable. You should be doing that really as a course of best practice at the moment. Somebody makes a request, you make a decision, you confirm it in writing, but double check your reasonableness element. I've just touched on here because there's not much information to go off, but we are expecting some changes in relation to bereavement leave and unpaid bereavement leave, looking to expand what bereavement leave covers, which I think is a well-needed change because at the moment it is very limited to certain circumstances like parental or children. Equality. So equality as a general topic is going to be covered. Employers with over 250 employees will need to provide equality action plans. These are going to be on topics such as the gender pay gap, and there will be financial penalties if you fail to do these. So it's now looking toward not just identifying if there are any equality issues in your business. What as a business are you going to do to look to try and bridge that gap and solve those problems? The Equality Action Plan is going to specifically reference menopause. So you may have seen this a lot in the news, a well-needed change that menopause is being considered as a disability under the Equality Act, which meets all those like specifications that it's a long-term illness, that it affects your day-to-day, etc. So the Equality Act is going to look for employers to consider how menopause is affected in your business. Contract workers. So actually, we're interested to see that as a business, you may also have to provide equality action plans or data on what are the gender split between any contractors or consultants that you use and why. And there's going to be enhanced protection for maternity returners. So those employees that if you've gone off on maternity leave and they've come back, they're going to have enhanced and longer protection with their employment. Okay, so I've done a little timeline here for you, just to kind of plot out what needs to be done immediately in April, October, and beyond. So, want you to look at immediately is auditing your probation period procedures. That is a major one. You should already be using probation periods, but now they're going to be more important than ever. It's going to be having regular checkpoints in your software to be like, when is that employee up for probation? Do we want them to remain in the business or not? Because remember, they only need 6 months service to make a claim for unfair dismissal. You no longer have 2 years to think about it. Review your SSP calculation processes. They're going to be SSP is going to be from a day one of sickness. So make sure your software, your systems are up to date to handle those changes, and check your union related policies. Before April 2026, so conduct harassment risk assessment. What risks to harassment are currently in your business and how can you look to rectify them? If you are using fire and rehire, really have a good review and a good think about whether that is appropriate for your business. One thing I didn't touch on earlier is that fire and rehire has a particularly bad PR element, so consider that. Update your settlement agreement templates. If we're going to be getting more claims, if we're going to be getting more disgruntled employees, perhaps, think about the use of settlement agreements and whether they are covering everything that you need. Prepare for extended tribunal time limits. So remember, they're now going to have 6 months to bring a tribunal claim. So have a think about it. That doesn't apply to all claims, but for your standard, for your unfair dismissals, have a think. Review your redundancy processes and review your family leave processes. Before October 2026, again, make sure your payroll systems are actually fully updated and ready to go so they kick into gear. Implement union notification processes. So how are unions going to be communicating with you? Get comfortable. Who's your contact at your business? Who's going to be dealing with unions? Train managers on day one family rights. Make sure they're up to date on the changes that are happening. Before 2027, redesign probation management, implement 0 hours tracking systems, and enhance your flexible working procedures. And start preparing for equality action plans. I've given you quite a list there, quite a to-do. But luckily, because the implementation is staggered, you don't have to do it all at one time. There are lots of resources out there that I would recommend that you keep up to date with. The most obvious is things like gov.uk, the ACAS. ACAS is the main body for all employment things and is a guru for us all. But also have a think about what you need to be doing internally with your processes. Right, so we've kind of come to the end of my section. So I've just highlighted some changes here. So navigate probation changes, manage your SSP compliance. Excuse me. It's just because it's so exciting, it's taking my breath away. Track your 0 hours and implement your equality action plans and reporting. Of course, Access is here to support you with both software solutions and expert guidance. We've got everything that you need all under one roof. Thank you for listening, and I'm going to hand over to my colleagues for the rest of the presentation.
Thank you, Bethan. I mean, that's been fantastic. I feel like I've written loads of notes and I'm learning stuff as we go as well. So thank you for such a comprehensive description of what this means. I hope that's been valuable to everybody. It's certainly been valuable to me, I like to say. But as I think Bethan's described, there's quite a lot of change coming. But actually, we've got you covered from an access perspective. And I'm just going to take a moment to talk through the way in which the software can be set up to support this and help automate some of the challenges that we've just described. So first and foremost, if we talk about the HR system, it's making sure your HR system is standardized and you have a consistent approach across the board for how your managers handle probation, absence, flexible working requests, but also making sure all that information is centrally secured and stored and fully auditable. Interestingly, again, Bethan was talking about some of the unions that are coming in place to be able to audit some of this, but your system can hold and secure all of that information for you. Day one rights was talked about quite a lot, but making sure that recruitment process is compliant as well, and we can assure that that process is compliant. And again, we talk heavily about documentation right from the get-go, from when somebody joins with you, safe and secure in a single location. Employee performance and feedback. So making sure that any of those performance reviews that take place are centrally managed means you can evidence those performance conversation in line with all of the expectations set out in the Act, as Bethan has just described. And then finally, we will talk a little bit more about this in a moment, but making sure your managers are trained. There's lots of training coming, making sure they're aware of what the requirements are and the obligations are on them and how they are able to support their employees with the changes that are coming in line with the Employment Rights Act. We have got, and we'll come on to this in a moment, we'll talk about some of the content that we have to really help with this in just a moment as well. So we've talked about a lot of the changes, we've talked about how the HR system can help, but how does it really help having a single ecosystem that manages all of this? So first and foremost, if we look at the policy updates, Access has got an in-house content production team for all digital e-learning. So the nice thing here is it's our responsibility to make sure that any training that we produce is in line with the legislation. So you can be rest assured that any training that you take or any digital learning that you take is always going to be in line with the latest legislation. And like I said, that's up to us and that's our responsibility to make sure that is done. Once an employee joins in People HR and their role is assigned, that role determines exactly what training is applicable and relevant and important for them, certainly from a compliance perspective. Again, so you can be rest assured that once an employee joins, they are automatically allocated by role the training that they need to ensure that they're compliant as well. And this means there's no gap between anything changing in law and your employees receiving training. It's our job to make sure that all the content that is on the system, on the platforms, is completely up to date. And that covers the compliance training, but also some of the wellbeing stuff as well. Having a single connected ecosystem means you've got analytics, reporting, etc., of who is and who isn't compliant. So you can easily identify where you need to take action if people need to do recertifying training and make sure they're up to date with the latest information, the training that is taking place. So it's easy to evidence that and be ready for any audits that might come your way as well. I think one of the biggest concerns, and again that was highlighted in the stats at the beginning, is the onus on managers to make sure they're aware of all the training. So making sure those managers are supported with the right training, with the right processes, and we've talked quite a lot about process in this, to make sure that they're there and they know what they are meant to be supporting their employees with. So we can use that information held against the manager to identify any gaps automatically, and then therefore make sure the correct training is assigned to them at the right time and trigger intervention as and when it's needed. We've talked a lot as well about consistency and making sure right from the very beginning we support the employee experience. So making sure they get given the right information at the right time and reducing that compliance risk, keeping your employees safe, keeping the business safe as well, and a consistent experience for all of those employees. Now, before I pass across to Andrea for the demo, which is probably the bit I expect you're all looking forward to seeing, is that we have created a suite of digital learning content that covers absolutely everything you need to know to train your employees on their obligations around the employment rights changes that are coming into place. So one of the key ones, for example, that Bethan has talked about is the changes to harassment. All of our content is updated in line with the latest legislation, that's hard to say, put my teeth back in, to make sure that your employees are aware of what their obligations are, etc. as well. We've also got things in here around providing, giving and receiving feedback, and the performance review process, which we've described earlier as well. So there's a whole suite of content here. They cover both compliance topics to make sure employees are understood and understand the latest legislation. We've also got some supporting wellbeing topics in here as well to help managers and employees as they navigate the changes over the next sort of 6 to 12 months or so. So without further ado, I will pass across to Andrea, who is going to show us how we cover this within the software.
Lovely. Thank you, Jess and Bethan. Obviously, really super useful. Loads of detail and loads of content there about the changes that we can be expecting over the coming months and years. What I want to do is just take 20 minutes to show you how your HR and your learning system can be used in order to help navigate some of those changes, in order to help support you, to help support your managers, and to help support your employees along the way with that. We're going to start off by looking at People HR and some of the changes that you can make in there and how you can utilize it in order to navigate these changes. So first and foremost, I'm logged in as a super user here within my solution. I'm looking at the current list of employees. The first thing that I will point out is obviously within Access, as most of you watching will know, we have a suite of products. I've got employee, I've also got, which is obviously People HR, I've also got learning within here, and I've also got Pay Circle, which is our payroll module as well. And all of those things are working together in harmony in order to help support all of those elements of compliance that we've spoken about as we go through here. Within HR, the changes that are coming in, I would say that logbooks are going to be your new best friend. We all know logbooks are essentially customized screens that you can create in order to log any information that you need to log about an employee. So for example, if I dive into an employee's record here within my HR system, if I go into Fiona Brown's record and go into her logbook section here, I have got a list of logbooks that I've created within my environment. So these are custom screens that I've created. Now, the beauty of that is that it gives you, as administrators of your system, the ability to create your own custom screens with your own custom data sets in it. So you might have requirements to record all sorts of weird and wonderful fields. You can utilize logbooks in order to do that. So I want to guide you through a couple of examples with regards to this. So one of the things Bethan was super clear on was probation reviews. So I have used logbooks in order to create probation review logbook forms so that I can record the information that I need to record for those probation reviews. You'll see here that I've actually got 9 months worth of probation reviews for this particular employee. Now, it could be the 6 months when we were talking about that initial 6-month period. It could be that you have probation reviews that cover different periods for different employees, and that's absolutely fine. The point is it can be customized to your processes. So my probation review logbook includes things like the date that the meeting was held, what stage it was. So I've got a custom drop-down list there, including a final probation review and one for each month of the probation review. Our managers would fill this out and they would detail how the employee is performing, if there's any areas that could be improved upon, what needs focusing on, have objectives been updated, the date of the next review, and if it's the last probationary review, what's the outcome of it? Is it something that we're passing? Fantastic if that's the case. Is it something that we're thinking is going to need extending, or are you talking about potentially exiting the employee from our organisation? So like I say, you could use the tools that you have within People HR in order to create any forms like this. Alongside my probation forms, I'm also using the workflow tool Ripple within People HR to help automate some of these things so they don't fall between the cracks, so that HR users aren't having to chase managers to complete these actions as well. So I am triggering from the probation review, from the date of the next review date there, I am triggering an email that goes to the manager 2 weeks before that due date in there that says, set up a meeting, have the meeting, and then fill out a form. You could also have reminders that go to managers and employees that tell them that they need to do these things if they haven't been done in a timely manner. Likewise, I'm also using a workflow in here that looks for the probation outcome field here. So if a manager has filled in a probation outcome and they've said that they're wanting to extend the employee's probation or even fail it, it will automatically create a message to my HR users who then can jump all over it, get in touch with the manager and sort out what needs to be happened and make sure those next steps are managed appropriately. Likewise, I've also got a different workflow where if the probation is passed, it automatically sends an email to the employee congratulating them on the fact that their probation is passed, and the HR team don't need to get involved if that's the case. So there are things like that that can help automate the process. Now, you could use logbooks, as I said, for anything within here. But again, there's lots of things within the Employment Rights Act that can really help with this. So, for example, it might be that you also use logbooks for things like flexible working requests, and you give employees the ability to add in logbook information for that. So if I'm an employee and I want to submit a flexible working request, I go into my logbook area, find my flexible working request, and I fill out all of the details that you need in order to make an assessment of that flexible working request. So your employees could be filling this out, and again, that could then be sending emails and notifications to HR teams, to managers, to tell them that a request has been submitted. Likewise, you could also use it for things like disclosures. So if an employee wants to disclose something or raise a grievance or something like that, Bethan talked about the disclosures of sexual harassment as an example. You could very well create a logbook screen so an employee can create a form within a system and send it. We all know those conversations must be incredibly difficult for people to have. So perhaps that would encourage employees to be able to report things that they don't necessarily feel comfortable talking to a person about. they could create the form, and that could be the first step on that process. Again, alerts could trigger then to HR for them to then get in touch with them and have a conversation in a very sensitive way. You could also use your logbooks for things like, what was I going to say there? You could also use your logbooks for trade union memberships as well. So you could well have a logbook form on here that looks at trade unions, where you could record the fact that people are a member of a trade union, the date they joined, the date the membership ended, if it has ended, and when they were communicated to about their rights to join a trade union. So there's lots of different examples where you can use your HR system here to record that information and start those processes going, backed up by your workflow tool in order to make sure that things are done in a timely manner. You might also use your HR solution to upload documentation as well. So any new policies, Bethan said about reviewing policies, any new policies that you wanted to update, you could absolutely put them on HR. What that gives your users to gives your employees and your managers is the ability to then ask questions of the system. So they can use the Copilot tool to come in here and ask questions. So they might come in here and ask a question such as, what unions can I join? What trade unions are available to me? And what the solution will do is it will have a look at all of the policies, all the procedures that that user has available to them, and it will return an answer for them. So rather than HR users and system administrators having to write detailed FAQs and expecting employees to be able to find those answers for themselves, or even having to come to you and ask you questions, self-service users can really self-serve. The names in the clues in the title, right? So as a user, I can come in here, I can ask Copilot a question, and it will return an answer for me based on the documents and the data that I have access to. You might also choose to use Copilot to access other areas of information as well. So we have links into different sort of websites, different pockets of information that are really helpful to HR users, to learning managers, and also to payroll managers as well. So for example, ACAS, we've got HMRC on here as well. So if I wanted to ask a question about changes in legislation, I can do that straight through Copilot. I can just pick ACAS as my skill. I could ask a question here and it will go up to ACAS's website, find the relevant answer, and then return it for me all within here without me having to browse to a different website or anything. It will return it in here. And then I can use my topic history to get back to it at any point that I might want to get back to it. So again, I don't have to worry about web browser histories or anything like that. It's all stored in here for me. You might also choose to use your Copilot tool to assess reports. So one area that Bethan mentioned is coming in the future is the ability or the need for employers to create equality action plans on reports. So if you use our PayCircle payroll solution that sits obviously within our Evo solution, you'll know that you can create really, really lovely detailed gender pay gap reports. Really simply, it takes about, I think, 2 minutes to pull off a full gender pay gap, and it will do it all for you there. I could download this and upload it to Copilot and ask it to come up with a plan for me based on the attached report that I gave it. So you can manage then your equality action plans and get AI tools to help you with that. Okay. Let's now turn our attention to the learning systems and how that can help. So the first thing I would say is, obviously, when we're managing our employees within People HR, that employee information is going to flow directly through to learning. So any new starters you have, any leavers, any changes to jobs, anything like that, that information is just going to flow straight through to learning. Now that gives obvious benefits of not having to set up employees in multiple different places, but it also gives us the benefits of making sure that learning is assigned automatically to employees dynamically. You wouldn't have to remember who needs to do what training, and if you've had a new starter, you wouldn't need to remember, oh, they need to do X, Y, and Z course. The system can manage that for you. So here I've just opened up my learning tab here. As a learner, I can see all of the learning that has been assigned to me. It could be learning, as I say, that's been automatically assigned to me via a rule that's created within the system that looks at my job title or my department or other tags, we call them, within our solution that would assign that. You'll see here, for example, I have my equality, diversity and inclusion course here. This is a management version of a course which has been assigned to me. I would have had a notification to tell me it's been assigned to me, and then I can come in and I can complete this learning directly within the solution. There is also a mobile app for this, I should say, as well. So any employees that are doing things like traveling and want to do some learning on the move, then they have the ability to do that as well. So I can come in here and I can complete this learning, and it will track where I am. So if I haven't got time to do the full learning course, I can navigate away from it, and then it will tell me kind of how far I am through it. It tells me how long the course is expected to take me, and also if it contributes towards my CPD as well. You can log CPD, or you can enroll employees on CPD programs, and as they complete learning, it will automatically add and contribute towards their CPD for the year. Now, as we mentioned, we do have different bundles of courses for different things. The one that we're going to be focusing on today is obviously all about compliance with regards to the Employment Rights Act, but we do have bundles of courses for other things as well. So whether it's like management skills, whether it's soft skills, whether it's things like cybersecurity or data protection, we have lots of different bundles of courses that you can take and utilize within the learning management system. If I just switch this up, and if we just say we want to go to our admin view of the system, because this person obviously is a self-service user, but they're an admin user in their own right. Within here, I can start to see things like the compliance score within my organization. So you can see how not compliant the employees in my test system are. I also, as an administrator, have the ability to manage content within here as well. So, for example, if we were looking to set up rules so that some of our courses are automatically assigned to our employees, I can just use my search tool here to find different courses that I might want to navigate, and then I have the ability to use rules within the solution in order to allocate training to employees as and when they join or when they move or when they leave. We can automatically create rules that will assign that learning. So within here, I could say I want all the people in these different job titles, for example, to be automatically assigned this learning. And then, as I say, when you have new starters, people change jobs, etc., that will automatically be assigned to them. We can set due dates, and we can say that actually this needs to be done by an employee, 2 months after it is assigned to them. Again, making it dynamic. You don't have to go in and update dates for employees. We could set things like certificate expiries as well. So if you've got a particular course that an employee needs to redo every year, you could have expiries in there as well. So it will automatically ensure that it's valid for a set period of time, and then it will re-enroll the employee on that course as and when they need to. We also have advanced kind of settings within here as well that allows us to put things like prerequisite courses. So you can link courses together and say, actually, employees need to do this course before they need to do this. You'd have diagnostic assessments as well to see whether employees need to have done or assess their learning before they do different pathways associated to those courses. So there's some really kind of cool and advanced things that you can do on a course as well. You can also categorize your mandatory training as well. So I've got 3 different categories that I've created there, but these would be your own categories. And that helps for your compliance dashboards. It helps for your reporting. So you could well have courses that are mandatory that relate to health and safety. You could well have courses that are mandatory that relate to compliance, such as what we've been talking about today. And you could report on those things separately using that categorization. Let me show you 2 ways that we would do that. So first of all, if I just go back to my learner view, so my employee view here, if I go to check in, this will show you a glimpse into what our managers can see within the solution. So the person that I'm logged in as here has one direct report, Mike. In here, I can see that Mike isn't doing particularly well at all with his compliance training. If I drill into his record, it will enable me to see the learning that he has been assigned and where he is at with that learning. Now, obviously, if I had multiple different employees, I would see a card for each of them. I can also view a team dashboard that will allow me to see the distinction between those different categories of compliance courses on here. So as a manager, I have that snapshot. Of course, as an administrator of the system, I have that snapshot as well. Or on top of that, I can also look at compliance dashboards that allow me to see that compliance as a whole, which is this first stat here. So this is my compliance for all of my learning that's deemed compliant related within the system on here. But then I can see it split down by its various different categories as well. So you can see I'm doing pretty well on my health and safety compliance, but I'm not doing very well at all on my induction compliant related training. And then again, I can see it split down by different org units and even by person as well. So if I wanted to see whether we had any gaps in particular areas of the business, if there were particular departments or particular areas that were maybe not doing quite so well with their compliance related training, I could see all of that within here. You can set, with regards to things like getting those compliant levels up, you can set things like email reminders against courses within the LMS. So if you wanted emails to be automatically sent to employees, to managers, if an employee hasn't done a course, or even on the run up to a due date of a course, those sorts of things can be set up within the solution as well. You can put your own wording. It can have links to the training content in it. It can merge in fields from the solution as well. So they look like dynamic emails and they have calls to action on them. So an employee can just click straight through. It will open up the software and get them to where they need to be in a matter of one click or a couple of clicks or less. All right. We do have as well within our learning tool the ability for people to create their own content. So again, if I just go back to my admin view here, I do have the ability to not only manage any content that is within the solution, but I do have what we call our creation tool, which gives us the ability to create content. So it's our e-creator. Now, you can either upload existing content that you have, or you can create, there's wizards within here that will allow you to create your own course content as well. So it doesn't just have to manage your compliance learning. You could create any sort of content that you might want. You can also use the learning tool to manage any events. So if you think about the changes that are going on for our in the employment law space at the moment, you might want to have an event that all of your senior managers attend, where they can see an update from you about what's going on and how that's going to be rolled out in your organization. You could use your e-learning tool in order to create an event to get people to be invited to that and manage the actual event itself. All right. Now, if that all seems a bit much for you in terms of the learning stuff, as we say, we've tried to make this kind of as accessible as possible. So if you didn't want access to the full LMS with the ability to create your own courses and do all of that sort of stuff, but actually the content and the ability for employees to digest that content would be really helpful, then we've created a bundle of content which is available via what we're calling our Learning Hub, which is basically like a reduced version of the LMS. So really good as an initial sort of welcome to the LMS, where you're able to choose the bundle of courses that you want. So you might just choose the content, the compliance bundle that we've been talking about today, where again you can go in, you can see that particular area of content, and you can allocate it to different groups of people depending on the content and who needs to see it. And then, just like I showed you a second ago, your employees would have the same user interface in order to be able to access and complete that content. So they would do it all from one hub, that they do their self-service from, that they book their holiday through, that they read your policies, that they see their timesheets, that they access their pay slips. They would also do their learning through that same portal. So there's not multiple usernames and passwords. There's not different places to navigate through. Everything is housed under one roof. So that was everything I was going to cover today. I'm going to hand back to Jess, and I think we're going to see if there are any questions that have come in.
Thank you so much, Andrea. That was fantastic. I think what's been really interesting there for me is that Bethan talked a lot about making sure your processes are ready for the upcoming changes, making sure your records are centrally stored. I think Andrea just demonstrated beautifully there actually how you can achieve all of that. So you can make sure the software is set up to support things like your probation processes, etc. Again, it's taking away that responsibility of individuals to remember to do these things, making sure it's working well for you to support in all of your obligations. So thank you. I think that's been really, really good. So I know we've only got 5 minutes left, so we might have to whiz through a few of the questions, but we'll pick out a few of them. I think Andrea actually covered quite a lot of them with her demo, which was really helpful. So we will be providing a copy of the recording after this session. If you'd like a copy of the slides, I'm sure we can get those across to you as well. Your account managers will be sort of following up with you with any questions that might be very pertinent to you off the back of this webinar. So that's all taken care of. A question here around that employment rights compliance bundle that we described, and you have to have the full LMS to access this. There's different options, I think, as Andrea, she covered that right at the end, which was brilliant because I was writing it down to make sure I told you. So there are options. So it's a suite of content, and whether you have the full LMS, which has all the kind of a lot more of the automation built in and the CPD functionality, etc., or you have a slimmed down version of the LMS where it's really about making sure the right people have access to the right training at the right time, then that is an option as well. Again, I'd certainly recommend discussing that with your account manager. That employment rights bundle is there. It's going to be launched in April, so a month away from where we are now. And obviously that will evolve. So as the regulation changes, etc., we will make sure that any of the changes that are coming into place in law will be reflected in that bundle. So there might be additional titles added into there to make sure that you have everything that you need in a single place as well. Well, someone wants a full day's training. I think that sounds like there's obviously quite a lot to consider here, but if you need more detailed demonstrations, more detailed conversations, we're absolutely happy for those to be picked up again. We'll make sure we pass that across to your account manager. Yes, the question is learning an additional cost? There is some learning already in the platform via Learning Lite, but certainly if we're looking to add on the full LMS and the employment rights bundle, there is an investment required there, but certainly talk to your account manager about that. Andrew, I don't know this one because it's an HR question. Can you bulk apply documents to all users like the company handbook? So if your company handbook's changing, can you get that out to everybody, make sure they've read it, etc.? I think you can actually do that in the LMS, thinking about it.
Yeah, you can. You can do it in either. In employee, so in people HR, under the documents. So if you're logged in as an administrator, the documents area on your menu on the left-hand side, go in there and you'll be able to upload a document. And when you upload a document, you can categorize it. So you could say this is a policy. You can create your own categories, you can create your own folders. And then when you add a document, you can specify the groups of people that you want to see that document. So you could specify that this needs to go to specific departments or specific areas, whether you want employees and or managers to access it. So you might have policies like your company handbook that's available to everyone. Great, you wouldn't need to put any restrictions on it at all. You might have some policies that are only accessible or only applicable to certain people, so you could restrict them as well. So the short answer is yes, do it through documents, but you can get more complex with it as well if you want to.
Thank you. Last one, and I know we're very light on time now, but can you add your own learning modules? You would need the LMS to do that. So if you've got some of your own learning that you want to centralise in a single place, that is feasible, but you'd need the learning management system to do that. And as Andrea demonstrated, you can create some of your own content as well. So if you've got things that are very pertinent to your business, you can record and create your own videos and put them on the platform as well. So I'm going to wrap up now, given that it's 1 minute to the end. But thank you very much, everybody, for attending. Thank you very much for engaging in all the questions. That's been really good. Very quick summary of the takeaways. The Employment Rights Act is law, so changes are already coming to effect and more are coming from April 2026. And it's not just about understanding what that is, but making sure you've got the structure, the process in place to support it and supporting your employees as well. We can really help you with that. So please talk to us, talk to your account manager. We can cover the HR structure, that recruitment process, performance management and the learning side of it as well. So your next steps, have a look at your current probation and your flexible working processes against the new requirements that Bethan described. Talk to your account manager. Make sure that you've got the system set up and optimised to support you. And obviously, we're very happy to talk to you about the Employment Rights Bundle as well. So thank you ever so much. Have a great afternoon. And yeah, we look forward to seeing you on a webinar again soon. Take care. Bye-bye.
Thank you. Bye.